Formation of a company means bringing a company into existence and starting a business, which involves a lot of legal formalities and procedures. Legal procedures can be divided into promotion, incorporation, and subscription of capital. Let us look at promotion of a company. Promotion involves conceiving a business idea by promoters and taking the initiative to form a company. Promoters analyze the prospects and bring together the men, materials, machinery, managerial abilities, and financial resources. Promoters are named in the prospectus, mentioned in the annual return, and have control over the running of the company. Let us look at the functions of a promoter. 1. Identification of business opportunity. This involves identifying a new product or service that is technically and economically feasible. 2. Feasibility studies. Technical and economic feasibility studies are conducted with the help of engineers, chartered accountants, etc., to examine whether the perceived business opportunity can be profitable. Technical feasibility. It might be a technically good idea, but sometimes it may not be feasible. For example, raw materials may not be available. Financial feasibility. The business has to work within the budget and funds raised by the promoters and should be profitable. Economic feasibility. Sometimes, even though a business is technically and financially feasible, the return on investment may be very low, so the business cannot be set up. 3. Name approval. 3 desired names, in order of priority, are given in the application to the Registrar of Companies, and whichever is available is allocated. This is old and replaced by SPICE plus system. 4. Fixing up signatories to the Memorandum of Association. Persons who sign the Memorandum of Association will be the first directors or subscribers of the company. 5. Appointment of professionals. Bankers, auditors, etc. are appointed to prepare documents to be submitted to the Registrar of Companies. The names and addresses of shareholders and the number of shares allotted to each are submitted to the Registrar in a statement called Return of Allotment. 6. Preparation of necessary documents and payment of registration fees. Legal documents are prepared to get the company registered. These are Memorandum of Association, Articles of Association, Consent of Directors, Agreement and Statutory Declaration. This is old process. Now it is done through SPICE plus system. Let us look at documents required to be submitted to the Registrar of Companies. 1. Memorandum of Association. The Memorandum of Association defines the objectives of the company. 1. Name. Clause. This clause contains the name of the company. 2. Registered office. Clause. This contains the name of the state in which the office of the company will be situated. Exact address is not needed at this stage, but must be decided within 30 days. 3. Objects. Clause. This defines the purpose for which the company is formed. 4. Liability. Clause. This clause limits the liability of the members. 5. Capital clause. This clause specifies the maximum capital that the company will be authorized to raise through the issue of shares. 2. Articles of Association. Articles of Association contain the rules regarding the internal management of a company, which should not contradict the Memorandum of Association. The articles generally contain matters relating to shares, such as value, transfer, buyback, allotment, forfeiture, conversion, dividends and stocks, directors, such as their powers, meetings and remuneration, auditing, such as accounts and the audit committee, winding up, etc. 3. Consent of proposed directors. Written consent of each person named as a director is required, confirming that they agree to buy and pay for qualification shares for a stake in the company in order to get the certificate of commencement of business. Each one is allotted a Director Identification Number, DIN, by the central government. This is old and now replaced by SPICE plus process. 4. Agreement. If the company needs any individual to be the managing director, the agreement with that person should also be submitted. 5. Statutory declaration. According to the textbook, a declaration stating that all the legal requirements pertaining to registration have been complied with, signed by a chartered accountant, is to be submitted to the registrar. Let us look at the position of promoters. Promoters are neither the agents nor the trustees of the company and are personally responsible for contracts entered into before incorporation. Promoters of a company enjoy a fiduciary position with the company, which they must not misuse. They must not hide any information about profits, etc. Promoters are not legally entitled to claim the expenses incurred in the promotion of the company. Let us look at the difference between memorandum and articles of association. The memorandum of association defines the objectives for which the company is formed, whereas the articles of association define the rules for the internal management of the company and how the objectives will be achieved. The memorandum is the main document and is subordinate to the Companies Act, whereas the articles of association are a subsidiary document. The memorandum defines the relationship of the company with outsiders, whereas the articles of association define the relationship between the members and the company. Acts beyond the memorandum are invalid, whereas acts beyond the articles of association can be ratified if they are not in violation of the memorandum or the Companies Act. Memorandum is compulsory, whereas the articles of association are not compulsory.